Good morning and welcome to the second meeting of 2025 in Session 6 of the Equalities, Human Rights and Civil Justice Committee. We have no apologies this morning. Our first and only agenda item today is the consideration of the Regulation of Legal Services Scotland Bill at Stage 2. I will briefly explain the procedure we will be following during today's proceedings for anyone watching. Members should have with them a copy of the bill, the marshalled list and the groupings. These documents are available on the bill webpage on the Scottish Parliament's website for anyone observing. I will call each amendment individually in the order of the marshalled list. The member who lodged the amendment should either move it or say not moved when it is called. If that member doesn't move it, any other member present may do so. The groupings of amendments sets out the amendments in the order in which they will be debated. There will be one debate on each group of amendments. In each debate, I will call the member who lodged the first amendment in the group to speak to and move that amendment and to speak to all the other amendments in the group. It would be helpful when speaking to amendments if members could be clear as to which amendment they are speaking to, given there are so many amendments. I will then call other members with amendments in the group to speak to but not to move their amendments, and to speak to other amendments in the group if they wish. I will then call any other member who wish to speak in the debate. Members wishing to speak should indicate that by catching mine or the clerk's attention. I will then call the Minister if she has not already spoken in the debate. Finally, I will call the member who moved the first amendment in the group to wind up and to indicate whether he or she wishes to press the amendment or to withdraw it. If the amendment is pressed, I will put the question on the amendment. If a member wishes to withdraw an amendment after it has been moved and debated, I will ask whether any member present objects. If there is an objection, I will immediately put the question on the amendment. Later amendments in a group are not debated again when they are reached. If they are moved, I will put the question on them straight away. If there is a division, only committee members are entitled to vote. Voting is by a show of hands, and it's important that members keep their hands raised clearly until the clerk has recorded their names. If there is a tie, I must exercise a casting vote. The committee is also required to consider and decide on each section and schedule of the bill and the long title. I will put the question on each of these provisions at the appropriate point. I should note that we will not go beyond the end of section 50 today. Before beginning proceedings, I want to welcome Minister Siobhan Brown. You're welcome. Thank you. So I call Amendment 1 in the name of the Minister, grouped with the amendments as shown in the groupings. Minister to move Amendment 1 and speak to all amendments in the group.
Good morning, Committee, and thank you, Convener. Before we turn to the first amendment, if I can just make a few remarks. We have before us in this bill an extraordinarily large number of amendments, so I intend to keep my remarks as short as possible to provide the committee with the information that members need, whilst also ensuring that we can proceed in a timely manner to deal with them all. And of course, I am happy to answer any questions that members may have. I also want to thank all of those who have engaged with the bill and supported the development of the amendments I have lodged. I want to take this opportunity to note the constructive engagement I've had with the Lord President and the Senior Judiciary, the Law Society of Scotland, the Faculty of Advocates, the Scottish Legal Complaints Commission, the Consumer Panel and the bodies represented on that panel in considering all of these amendments. Draft amendments were shared with the Senior Judiciary and I have reflected carefully on their comments. I note the comments of the Lord President in his letter to the committee on the 23rd of December, in which he notes that the significant concerns have been addressed and the Senior Judiciary are broadly content with the amendments that have been lodged. And I also welcome the comments of the Law Society in their letter to the committee on the 10th of January, where they share this view. I hope that the committee and stakeholders are reassured by these comments and can support the amendments. I acknowledge that this bill has attracted differing views from stakeholders, and it is these differing views that we've had to balance as we aim to modernise the regulatory system. I consider that if the amendments proposed at stage 2 are agreed, the bill will achieve the right balance in those terms, in delivering the priorities of the stakeholders and deliver a modern, more flexible regulatory system. Convener, let me now turn to the amendments, starting with Amendments 2 and 43. The Law Society of Scotland, the Faculty of Advocates and the Senior Judiciary all raised concerns at stage 1 about the provision in the bill which confer powers onto Scottish ministers. The Scottish Government absolutely recognises the importance of an independent legal profession and is committed to upholding that independence. It has been the intention of this bill that it would protect the independence of the legal profession while introducing greater transparency and accountability in terms of their duty to work in the public interest. I wrote to the committee in September 2023 to say I would bring forward amendments and remove the references to Scottish ministers which caused concern, and I confirm this again in response to the Stage 1 report. Amendments 2 and 43 are the first of a number of amendments that remove this provision, and the committee has been provided with a list highlighting which they are. As this is the same change throughout the whole bill, I'm not going to repeat the reasoning in each group. Amendment 43 will remove Section 5 of the bill, which would have conferred a delegated power on the Scottish ministers to amend the objectives of legal services regulation and the professional principles to which persons providing legal services should adhere. And Amendment 2 is a consequential change, consequential to that change. Amendment 3 makes a change to Section 1, removing the reference to the ministerial powers in Section 19 and 20 of the bill. It is consequential on amendments to those sections which have the effect of transferring the powers under those sections from the Scottish ministers to the Lord President. Amendments 1, 4, 38, 39, 40, 41 and 46 are technical amendments to clarify the language in places in Part 1 of the bill. Amendment 42 adds the Scottish Solicitors Discipline Tribunal to the list of named regulatory authorities in Section 3.5, to which the regulatory objectives apply, omitted by the bill. Following discussion with the Scottish Mediation, Amendments 44 and 45 clarify the meaning of legal services to ensure the definition does not include alternative dispute resolution activities. And I move Amendment 1 in my name, and I ask that members to support the other amendments in this group. Thank you, Convener.
Okay, thank you. Could I ask Maggie Chapman, please?
Thanks very much, Convener, and good morning, Minister. Thank you for that. Can I just ask, for amendments 40, 41 and 42, that you've just spoken about latterly, the regulatory authority, the powers only need to be carry out their duty as far as practicable. Can you just say a little bit more about how the general understanding of as far as practicable is, just so we have clarity on that point?
Certainly. So Amendment 41 makes it clear that the requirement to exercise regulatory functions in a way that contributes to sustainable economic growth applies only to the extent that it would not be inconsistent by the regulatory objectives to do so, rather than with the exercise of regulatory functions as it does present. This amendment addresses the Law Society's concerns that exercising regulatory functions only to an extent is not inconsistent with the exercise of regulatory functions was circular and confusing. So this amendment makes it clear in section 314B of the bill that the duty to exercise regulatory functions in a way to help achieving economic growth only applies to the extent that it's not inconsistent with the regulatory objectives as set out in section 2.1 of the bill. And moving on to amendment 42, that adds that the Scottish Solicitors Discipline Tribunal as a named regulatory authority in section 3.5, and this means the regulatory authority, the SSDT, is subject to the duties as set out in section 3, and these duties relate to how the regulatory objectives are applied and other regulatory authorities, including the Lord President, the Category 1 and the Category 2 regulators.
Thanks. I thought it was just helpful to have that on the record for these amendments. Thank you.
Thank you. And I call Paul O'Kane, please.
Thank you very much, Convener. I thought it would just be helpful before we move into lengthy consideration of the amendments before us to put on record some general comments in relation to this section and ministerial powers which apply to the amendments in this group, so that then I won't have to repeat comments in any of the subsequent groupings. I think for those of us on the committee who had heard the stage 1 evidence in the bill, it was clear that the bill did not start out in a place where I think there was consensus, or a degree of consensus certainly, and I think there was much concern about the level of warnings that came from respected organisations, including the Law Society, the Faculty of Advocates and indeed the senior judiciary itself, which in many ways was unprecedented. And such were many of the levels of concerns about the threat to the independence of the judiciary from the imposition of ministerial powers that the bill did seem at points to be quite significantly flawed and was going to require subsequent amendments as are before us today. So in saying all that, I do think that credit should be given to the Minister and the team of officials for the work that they have done over many months in terms of these amendments and work with stakeholders, I think, to sufficiently address risk. And I would like to thank the Minister for the constructive engagement she's had with me in listening to many of those concerns on these aspects of the bill, and also more widely in terms of offering, I think, a collegiate way in working to address some of these issues. I do hope that we will continue through stage 2 consideration and then in stage 3 with that collegiate approach. I still have some areas of concern more widely in the bill. I won't, of course, expand on those now because it wouldn't be appropriate. And to avoid me dragging on for too long, I just want to confirm my support of amendments in this group and keen, as we look through the remaining amendments, to continue this debate as we move. So I'm very grateful to you, Convener.
Thank you. We now call Tess White, please.
Thank you, Convener. It's in relation to Amendment 40, Minister. So, and I'm hoping that when you do your winding up, if you could address this point, I'd be grateful. So the SLCC has raised concerns about Amendment 40, and it looks like a minor drafting adjustment, but when one looks at it more closely, it does seem to make a substantive change by qualifying the application of regulatory objectives, and it's therefore no longer a duty. So it does change it. So I'd like the Minister, please, to respond to the SLCC's comments in relation to that. Thank you.
Sure. Do any other members wish to come in before the Minister winds up? No, I invite the Minister to wind up, please.
Thank you very much, Convener. If I could just address, I will thank Paul O'Kane for his comments. And I know that this has been a bit of a journey, this bill, since it was introduced in April 23. And I hope that members of the committee will now appreciate, I know when we went into stage 1, that members did want to see all the amendments at that stage, the amount of work that's had to take place and discussions with the judiciary and the Lord President to get us to where we are today. And it's thanks to my officials, there's been a lot of work in the background going, but I feel that we are in a better place today than we were maybe this time last year. So I thank Paul O'Kane for his comments on that. Tess, just going on to Tess White's comments from the SLCC on Section 40. There's been a lot of engagement with stakeholders in the whole process of this bill. The purpose of Amendment 40 is to clarify that the duty under Section 3 of the bill of the regulatory authority to exercise its regulatory functions in a matter which is compatible with the regulatory objectives and is considered the most appropriate to meet the objectives is not an absolute duty. So the regulatory authority need only to carry out the duties as far as practical. Now, the effect of this amendment is to insert the words so far as practical into section 3(1) of the bill, so that the regulatory authority need only apply the regulatory objectives so far as practical. And this amendment going in has reflected many discussions with the Law Society and getting agreement with that. So that's where we've come to that conclusion with section 40.
Minister,
Amendment 40.
if I may, and the SLCC, so you mentioned the Law Society in relation to this amendment.
Yes, well, this is what we've decided after engagement, that it's the right way forward.
The question is that Amendment 1 be agreed to. Are we all agreed? Yes. We are agreed. I call Amendments 2, 3 and 4, all in the name of the Minister and all previously debated with Amendment 1. I invite the Minister to move Amendments 2 to 4 en bloc.
Moved en bloc, Convener.
Does any member object to a single question being put on Amendments 2 to 4? No? The question is that Amendments 2 to 4 be agreed to. Are we all agreed? Yes. We're all agreed. The question is that Section 1 be agreed to. Are we all agreed? Yes. We're all agreed. I call Amendment 38 in the name of the Minister, already debated with Amendment 1. Minister to move formally.
Moved, Convener.
The question is that Amendment 38 be agreed to. Are we all agreed? We're all agreed. I call Amendment 39 in the name of the Minister, already debated with Amendment 1. Minister to move formally.
Moved, Convener.
The question is that Amendment 39 be agreed to. Are we all agreed? Yes. We are agreed. The question is that Section 2 be agreed to. Are we all agreed? Yes. We are all agreed. I call Amendments 40, 41 and 42 all in the name of the Minister and all previously debated with Amendment 1. I invite the Minister to move Amendments 40 to 42 en bloc.
Move, Convener, en bloc.
Does any member object to a single question being put on Amendments 40 to 42? The question is that Amendments 40 to 42 be agreed to. Are we all agreed? Yes. We're all agreed. The question is that Section 3 be agreed to. Are we all agreed? Yes. We're all agreed. The question is that Section 4 be agreed to. Are we all agreed? Yes. We're all agreed. I call Amendment 43 in the name of the Minister, already debated with Amendment 1. Minister to move formally.
Moved, Convener.
The question is that Amendment 43 be agreed to. Are we all agreed? We are all agreed. I call Amendment 44 in the name of the Minister, already debated with Amendment 1. Minister to move formally.
Moved formally, Convener.
The question is that Amendment 44 be agreed to. Are we all agreed? Yes. We are all agreed. I call Amendment 45 in the name of the Minister, already debated with Amendment 1. Minister to move formally.
Move, Convener.
The question is that Amendment 45 be agreed to. Are we all agreed? Yes. We are all agreed. The question is that Section 6 be agreed to. Are we all agreed? Yes. We are all agreed. I call Amendment 46 in the name of the Minister, already debated with Amendment 1. Minister to move formally.
Moved, Convener.
The question is that Amendment 46 be agreed to. Are we all agreed? Yes. We are all agreed. The question is that Section 7 be agreed to. Are we all agreed? Yes. We are all agreed. I call Amendment 47 in the name of the Minister, grouped with amendments as shown in the groupings. Minister to move Amendment 47 and speak to all amendments in the group.
Thank you, Convener. Amendments 47, 522 and 466 make the necessary changes to legislation to reflect the change of name of the Association of Commercial Attorneys to the Association of Construction Attorneys. The Association sought this change following the introduction of the bill, and this was approved under Section 42 of the Law Reform Miscellaneous Provision Scotland Act 1990. Schedule 1 of the bill makes a variety of changes to the Solicitors Scotland Act 1980 in respect of the Law Society becoming a Category 1 regulator and the move to entity regulation. Amendments 5 to 37, accepting 15, 24 and 27 are minor or consequential modifications to Part 1 of Schedule 1 relating to the Law Society's functions. Amendment 24 removes paragraph 22 from Part 2 of the schedule of the bill, which is no longer required. Amendments 412, 413 and 507 make consequential amendments following the change of name from the Guarantee Fund to the Client Protection Fund in the bill. Amendment 11 allows the Client Protection Fund to provide grants as well as loans to judicial factors appointed in order to mitigate the risk of any further losses suffered by the clients of such a person by reason of dishonesty. This reflects engagement with the Law Society, who sought this addition. Paragraph 6.6 of Schedule 1 inserts a new section into 1980 Act to enable the Scottish ministers to, by regulations, adjust Section 43 and Schedule 3 of the 1980 Act in respect of the circumstances when claims can be made, the maximum amount of any grant payable, and in connection with administrative matters. Amendment 15 restricts the exercise of this regulation-making power to only those cases where the Scottish ministers have received a request from either the regulator or the Lord President or the Consumer Panel to do so. Before making such a request, the requester must have consulted with the Regulatory Committee, the Lord President and the Consumer Panel, and must have also secured the Lord President's agreement to making the request. The provision sets out what information must be provided to the Lord President when seeking their agreement and requires the requester to publish certain documents. Amendments 461 to 465 make minor and consequential modifications of enactments in connection with regulatory objectives, professional principles and new regulators in Part 1 of Schedule 3 of the Bill. I move Amendment 47 in my name, and I ask members to support the other members in the group.
Thank you. Would any members wish to come in? No. Would the Minister like to wind up?
No, thank you, Convener.
Thank you. The question is that Amendment 47 be agreed to. Are we all agreed? Yes. We're all agreed. I call Amendment 48 in the name of the Minister, grouped with Amendments 49 and 50. Minister to move Amendment 48 and speak to all amendments in the group.
Move, Convener.
Okay. Yeah. Does the Minister wish to speak to the amendments?
Oh, sorry, I'm going on to Group 3. Yes, sorry. Apologies, Convener. Convener, Amendments 48 to 50 are in response to concerns raised by the Delegated Power and Law Reform Committee and legal stakeholders that Section 8 may be used to alter the categorisation of the Law Society or the Faculty of Advocates. The amendments reduce the breadth of the delegated power to be conferred by Section 8(5). As amended, this power allows only for the category of a regulator that is assigned by the bill to be altered by the Scottish ministers, for example, on a significant change in the regulator's composition or the way it operates. The power does not capture the Law Society or the Faculty of Advocates. In addition, as an additional safeguard, the regulation-making power may only be exercised at the request of the Lord President. Amendment 49 is a technical amendment to add a more specific cross-reference to the power, and I move Amendment 48 in my name, and I ask that members support the other amendments in this group. Thank you, Convener.
Thank you. Does any member wish? No? Okay. Would the Minister like to wind up?
No, thank you, Convener.
Thank you. The question is that Amendment 48 be agreed to. Are we all agreed? Yes. We are all agreed. I call Amendment 49 in the name of the Minister, already debated with Amendment 48. Minister to move formally.
Moved, Convener.
The question is that Amendment 49 be agreed to. Are we all agreed? Yes. We are all agreed. I call Amendment 50 in the name of the Minister, already debated with Amendment 48. Minister to move formally.
Move, Convener.
Thank you. The question is that Amendment 50 be agreed to. Are we all agreed? Yes. We are all agreed. The question is that Section 8 be agreed to. Are we all agreed? Yes. We are all agreed. I call Amendment 51 in the name of the Minister, grouped with amendments as shown in the groupings. I draw members' attention to the procedural information relating to this group as set out in the groupings. Minister, if you could move Amendment 51 and speak to all amendments in the group.
Thank you, Convener. Amendments 51 to 72 bring the provisions relating to the exercise by Category 1 regulator of its regulatory functions by an independent regulatory committee established and maintained by them in line with the equivalent provisions in the Solicitors Scotland Act 1980, which apply to the Law Society's committees. The amendments reflect engagement with the Law Society. Taken together, the effect of Amendments 51, 52 and 53 is to require rather than allow the Regulatory Committee to determine its composition, governance arrangements and priorities in accordance with the Bill. Amendment 54 ensures a Regulatory Committee can continue to delegate its functions. Amendment 64 allows subcommittees to delegate any of its functions to an individual, such as a member of staff. Delegation to a subcommittee or onwards to an individual is subject to some exceptions relating to the Regulatory Committee's function of making regulatory rules and decisions around complaints. Amendment 56 introduces a requirement on the Regulatory Committee to maintain and publish a document setting out its composition, governance arrangements, regulatory functions and procedures, and any arrangements for the delegation of functions. Amendments 57 and 58 limit the consultation requirement on the Regulatory Committee to consult the governing body of the regulator to only those cases where the committee is making a material change to its governance arrangements rather than a less significant change to either its structure or governance arrangements. Amendment 60 to 63 makes changes to the rules and requirements relating to the composition, membership and procedure of the regulatory committees, with Amendment 59 making a minor technical change to clarify the meaning of Section 53(3). Amendment 65 removes the requirement to include the summary of decisions to pay out professional indemnity insurance from the annual report to reflect concerns raised by the Law Society that it is the insurance provider and not necessarily the regulator who has access to that information. Amendments 66, 67 and 69 increase the range of material that must be included in the Category 1 regulator's annual report to include information about the number of complaints and regulatory waivers. Amendment 68 is consequential on the transfer of the powers from the Scottish Ministers to the Lord President under Section 20 to take specified measures in relation to Category 1 regulator. Following engagement with legal stakeholders, Amendment 70 removes the requirement on a Category 1 regulator or its regulatory committee to consult the Lord President when preparing an annual report. Instead, Amendment 71 will require that the regulator send a copy to the Lord President as well as publish it. Amendment 73 makes minor clarificatory changes to the interpretation provision in Section 13(7), setting out how conduct and regulatory complaints are to be construed and to clarify that a regulator's reporting year means a 12-month period that coincides with the regulator's financial year. Section 14 of the Bill requires a Category 1 regulator to establish and maintain a compensation fund. It also gives the Scottish Ministers the power by regulations to make further provision in connection with the fund or fund rules. Reflecting on engagement with legal stakeholders, Amendment 74 will restrict the exercise of this ministerial power to cases where either the Lord President or the Category 1 regulator or the Consumer Panel has requested them to do so. The amendment specifies the information that must be included with such a request and sets out who must be consulted before such a request is made. When the Lord President's agreement must be secured, as well as information must be given to the Lord President when seeking their agreement. Amendment 75 makes regulations made under this power subject to the affirmative procedure aligning with Schedule 1, Paragraph 6 and inserting Section 43A into the 1980 Act in respect of the Law Society Guarantee Fund, which is delegated power subject to the affirmative procedure. Section 16 requires a Category 2 regulator to prepare and publish online an annual report on the exercise of its regulatory functions. The section also specifies what information the report must include. Amendments 76 and 77 require additional information to be included in that report. Amendment 78 makes a consequential change to Section 12(2)(g) to reflect the fact that Amendment 112 changes Section 20 of the Bill to allow the Lord President, rather than the Scottish Ministers, to take specified measures in relation to the performance of a Category 1 or Category 2 regulator. And under Section 16, the annual report must include details of the steps taken by the regulator to comply with any such specified measures. Amendment 79 accepts the faculty of advocates as a regulator from the requirement to include in the report a statement indicating whether it considers it has been assigned to the correct category in line with the adjustments in Section 8. Amendment 80 requires a Category 2 regulator to consult the Consumer Panel when preparing an annual report to ensure consumer interests are considered. Amendment 81 makes it a requirement for the Category 2 regulator to send a copy of its annual report to the Lord President in addition to publishing it, and it was included following engagement with stakeholders. Amendment 82 clarifies that a conduct complaint is to be construed in accordance with Part 1 of the 2007 Act in respect of Category 2 regulator annual report. Amendment 83 changes the definition of reporting year to mean, in relation to a Category 2 regulator, a 12-month period that coincides with the regulator's financial year. Convener, the other amendments in this group expand on the information that regulators must hold about members in their register required under Section 17 of the Bill. They also widen the definition of professional liability, which brings the definition in this bill more in line to the definition in the Solicitors Scotland Act 1980. Amendments 84, 88 and 90, 84 to 88 and 90 expand the information that is required to be held by regulators on the mandatory register about its members. This includes information around the business address, any sanction resulting from disciplinary action, suspension, and what is required after a period of suspension has been lifted, and to provide further transparency about the outcome of disciplinary action. These amendments were included following engagement with stakeholders. Amendment 89 allows the regulator to decide what additional information the register may contain as the regulator considers appropriate. Amendments 91 and 92 widen the definition of professional liability in Section 18(7), professional indemnity insurance, to include former legal services providers and to cover other services in addition to legal services forming part of the professional practice of the solicitors or qualifying individuals within the legal businesses that provide the legal services. The definition draws on some of the elements of the 1980 Act definition. Convener, I move Amendment 51 in my name, and I ask that members to support the other amendments in this group.
Do any members wish to come in? Does the Minister like to wind up?
No, thank you, Convener.
Okay. The question is that Amendment 51 be agreed to. Are we all agreed? Yes. We are all agreed. I call Amendments 53, 52, 54, 55, 56, 57 and 58, all in the name of the Minister and all previously debated with Amendment 51. I invite the Minister to move Amendments 53, 52 and 54 to 58 en bloc.
Moved en bloc, Convener.
Thank you. Does any member object to a single question being put on Amendments 53, 52 and 54 to 58? No member objects. The question is that amendments 53, 52 and 54 to 58 be agreed to. Are we all agreed? Yes. We are all agreed. The question is that section 9 be agreed to. Are we all agreed? Yes. We are all agreed. I call amendments 59, 60, 61 and 62 all in the name of the Minister and all previously debated with Amendment 51. I invite the Minister to move amendments 59 to 62 en bloc.
Moved en bloc, Convener.
Does any member object to a single question being put on amendments 59 to 62? No. The question is that amendments 59 to 62 be agreed to. Are we all agreed? Yes. We are all agreed. The question is that section 10 be agreed to. Are we all agreed? Yes. We are all agreed. I call amendment 63 in the name of the Minister, already debated with amendment 51. Minister to move formally.
Move, Convener.
The question is that amendment 63 be agreed to. Are we all agreed? Yes. We are all agreed. The question is that section 11 be agreed to. Are we all agreed? Yes. We are all agreed. I call amendment 64 in the name of the Minister, already debated with amendment 51. Minister to move formally.
Move formally, Convener.
The question is that amendment 64 be agreed to. Are we all agreed? Yes. We are all agreed. The question is that section 12 be agreed to. Are we all agreed? Yes. We are all agreed. I call amendment 65 in the name of the Minister, already debated with amendment 51. Minister to move formally.
Move formally, Convener.
Yeah. The question is that amendment 65 be agreed to. Are we all agreed? Yes. We are all agreed. I call amendment 66 in the name of the Minister, already debated with amendment 51. Minister to move formally.
Move formally, Convener.
The question is that amendment 66 be agreed to. Are we all agreed? Yes. We are all agreed. I now call amendment 541 in the name of Tess White, grouped with amendments as shown in the groupings. I draw members' attention to the procedural information relating to this group as set out in the groupings. Tess White to move amendment 541 and speak to all amendments in the group.
Thank you. So thank you, Convener. The amendments in this group are probing amendments. I've lodged them because my colleagues and I believe that the RLS bill doesn't go far enough in creating a simplified and streamlined complaints process for consumers. However, it's not just an administrative process, it cuts to the core of the balance of power between lawyer and consumer. It's about who does what in the regulatory and complaints handling landscape. Lawyers do play an important role in challenging governments on behalf of their clients, but who guards the guards? Is it right that a membership body for the legal profession should also regulate the misconduct of its members? And that is a very important point. It shouldn't be David and Goliath, but that's what we have at the moment when things go wrong. For consumers of legal services, it's not always clear where self-regulation ends and self-interest takes over. The view of the Scottish Conservatives is that these issues haven't been satisfactorily addressed in the bill before us. And against this background, my amendments in this group form a package which does seek to change the system of complaints handling so that only the Scottish Legal Complaints Commission would consider complaints, not the professional bodies. In the 2018 Roberton Review, it was clear that the existing complaints and redress process is not fit for purpose. Esther Roberton's diagram of the current system is eye-opening, it's quite alarming, and as my colleague Russell Finlay said at stage 1, the Tokyo Metro map is easier to understand. While I didn't sit on the EHRCJ committee when Stage 1 report was published, I note the finding at paragraph 144 that, and I quote, "The committee is concerned that the Scottish Government may have missed an opportunity to take a simple, more friendly approach in creating a single, streamlined complaints process which would have benefited customers consumers and regulators alike. Now, I've worked with the legislation team on how best to address this recommendation, and that's against the backdrop of a very complex and very legalistic framework. Members will appreciate that the single complaints process in the Roberton Review depended on the creation of an independent regulator, and I acknowledge that the ship has sailed, at least for now. And I think those quotes have been used, the ship has sailed, so I do acknowledge that. But at the moment we have a single gateway for complaints, but not a single investigation process, and as such, this package of amendments uses the existing infrastructure of the SLCC to investigate all conduct and service complaints. Now, I've engaged with the Law Society on this proposal, and I note its correspondence to the committee on the 17th of January, the position it has laid out against my amendments. And I similarly note the submission we received last night from the Faculty of Advocates, which argued against a single complaints process. The position of the regulators is not unexpected or unsurprising. I recognise they believe more regulatory powers are essential to improving the complaints process, and that they strongly oppose any structural change, and that is, of course, their right to do so. However, the faculty said in its latest response that this proposal is, and I quote, a hare that was considered to have been caught and shot long ago. I respectfully disagree. Just because the regulators oppose a single complaints process doesn't mean that we should not continue to discuss or debate it. The consumer must have a voice too. The SLCC has engaged constructively on my amendments, arguing that a single complaints process would be in the, and I quote, best interests of the public, consumers, the legal profession and the representative bodies. It would be, quote, more efficient, allow greater flexibility and reduce inefficiency, duplication and delay. This approach would in many ways satisfy paragraph 144 of the committee's Stage 1 report on complaints, but it isn't a cure-all, and I recognise stakeholder concerns about cost implications and also about the complexity of the 2007 Act, which was foundational for the SLCC. Minister, my amendments are therefore probing at this stage. I would value the opportunity to work collaboratively with the Minister and stakeholders ahead of Stage 3 if it means we can further improve the complaints process for consumers. I move Amendment 541 in my name. Thank you.
Thank you, Jen. Other members wish to contribute? Paul O'Kane, please.
Thank you, Convener. I'm very grateful. And at this stage, I would put on record thanks to the many stakeholders who provided briefings in advance, and some were referenced by Tess White, Law Society, SLCC, Faculty of Advocates and others, and indeed produced those in quick order since last week's lodging deadline. On the amendments in this group, they are not something that I would support, although I appreciate what Tess White has said about the probing nature of her amendments. I think the probing nature of the amendments allows a useful opportunity to discuss and debate why government alighted on maintaining the current divisions in terms of regulatory duties rather than establishing a new regulator. And I think the reasons why I wouldn't support the moves within these amendments to shift all complaints proceedings to the SLCC are much the same as I think the view the committee arrived at in terms of its consideration of the evidence presented to us at Stage 1. I think we would recognise that there are significant challenges within the complaint system at the moment. I think everyone would acknowledge that it is complex, it can be inefficient and it can be slow, which of course creates a bad experience in many regards for consumers of legal services who wish to raise a complaint. But I think what the bill is trying to do and has tried to do through its genesis is to go some way to address some of those issues. And indeed, I, as well as many of the stakeholders I've spoken to, want to see change effected sooner rather than later. So I think to go through a lengthy process at public expense over many, many years to transition functions that are currently conducted by the Law Society and then the faculty could mean significant delays for consumers who do need improvements right now. And I think even if we were to have chosen either to go through amendments at an earlier stage of the bill's conception, I don't think we would have had perhaps some of the noticeable benefits that are now coming through. I've also, as I've referenced, I think putting new structures in place and putting new duties upon the SLCC would perhaps require quite a breadth and depth of reform and change to the SLCC, not least in terms of their resource and staffing. I think there's also a fundamental principle here, which I'm interested in. The point that membership organisations should have an obligation to monitor, investigate and, if necessary, take action on the conduct of their members. I think that's in essence what we are debating here today, ensuring that organisations like the Law Society, for example, feel and actually exercise their duty to look after and ensure the highest conduct standards of their members, in much the same way as we would expect regulation from other bodies in our public life of their members. I perhaps would posit that political parties, for example, would be an example where the regulation of members is ceded to the political party of their members. So I don't want to go on at length, Convener, because I think many of these issues have been debated already and covered in the Stage 1 report. But I do think there are many reasons why the broad solutions to the challenges faced in legal services regulation right now that are relied on in the current bill are preferable perhaps to the ones that have been outlined in the amendments in the name of Tess White. As I say, I don't want to go over old ground, and I think I will leave my comments there. But I do think when we return to this, if we return to this at Stage 3, it will be important to continue to recognise some of the things that I have outlined. Thank you.
Okay. Does any other member wish to come in? Maggie Chapman, please.
Thank you very much, Convener. And I thank both Tess White and Paul O'Kane for this discussion, because I think it is useful for us to air some of these views. I really just would ask that the Minister in her contribution talk specifically about some of the concerns that were raised by the committee in our Stage 1 report because of the evidence outlined that Paul O'Kane has referred to around the complexity and exactly how the Minister's proposals for this part of the bill actually do, whilst retain some of the issues and complex nature that we've heard about, do streamline it, because I don't think we necessarily have that overall picture when we look at the amendments taken as a whole in the section. And I think it would be helpful for the Minister to clarify, and possibly in response to some of the questions that were raised by Tess White in her comments, exactly why this complexity can't necessarily be dealt with in the way that Tess White's amendments suggest that they might. Thank you.
Thank you. Any other member wish to come in? No? Minister, please.
Thank you, Convener. So the Scottish Government recognised the differing views from the Esther Robertson's report's primary recommendation, and so committed to seeking a wide range of views through the consultation to inform the shape and the extent of the reform moving forward. The bill does take a proportionate approach that seeks to balance and deliver the key priorities of all stakeholders and is shaped by the responses to the consultation. And as I said in my opening statement, it is these differing views that we've had to balance as we try to we aim to modernise the regulatory system. The consultation highlighted that views were evenly split between support and opposition to the primary recommendation. And however, I think it is really important to state that there are many areas where there is broad agreement between stakeholders, such as the introduction of entity regulation, protections around title lawyer, and improvements to the complaints system. And I think it is agreed by both sides of the polarised views that there's long overdue reform is needed with this bill. The bill will require that regulators of legal services exercise regulatory functions independently of other functions and activities. So removing complaint handling from the regulators, the bill as introduced reflects the position of 60% of the respondents supporting, retaining and improving the current position in respect of responsibility for complaints handling. So it was considered important that the body representing for setting the rules should deal with conduct complaints in relation to the failure failure to adhere to those rules. Now, the SLCC will remain the single gateway for all legal complaints against legal practitioners for consumers of legal services, with a limited exception. Where a complaint is identified by a regulator, it will be able to investigate it immediately. The bill will introduce a more efficient and flexible system to allow complaints to be dealt with more swiftly. The Scottish Government has given very, very careful consideration to which bodies should have responsibility for investigating conduct, services and regulatory complaints. And while there is general agreement that improvement is needed, there is another area where there is significant divergence of views to what improvements should look like, which I think everybody appreciates, trying to balance moving this bill through. Whilst the bill retains a multi-agency approach, it also introduces changes which will vastly simplify and strengthen the process to the benefit of consumers, practitioners and the bodies responsible for handling complaints. The bill establishes a new legislative framework which will allow the SLCC to design its own flexible and responsive complaint system. It is intended to create a system which is proportionate in terms of how complaints are processed. The bill also removes steps within the current system which slow down the investigation of complaints by allowing the Law Society and the faculty to raise a complaint and directly investigate it without first going through the SLCC in certain circumstances. And the introduction of these new systems, as well as a new ability for the SLCC or the regulator to initiate its own complaint, will be hugely beneficial for consumers and practitioners alike. The Scottish Legal Complaints Commission currently has a role in monitoring trends in legal complaints and making regulations which the regulator does not have to comply with. This bill will build on this to provide greater independent oversight of complaint handling by allowing the SLCC to set minimum standards in consultation with the regulators and the Lord President, which will ensure consistency and best practice in the way that complaints are handled, and means that consumers should receive redress quickly as possible, and fewer complaints should reach the SLCC. Setting minimum standards for regulators will also improve the experience for those who have a complaint to lodge and for practitioners. And the committee heard evidence from Rosemary Agnew and the Scottish Public Services Ombudsman that this approach is the best practice. I appreciate in this session of Stage 2, we are focusing a lot on removing the ministerial powers and all the legal aspects of the bill. And I know that in future sessions we will be looking at how the consumer interests are being strengthened, and also the improvements to the complaints system. And the voice of the consumer will be placed at the heart of legal regulation by the expansion of the Consumer Panel's remit. The panel will be able to make recommendations in areas such as client relation rules and price transparency. The introduction of the consumer principles will reinforce this, as the bill will require that the views of consumers should be understood and taken into account. I note the concerns that have been raised by the Law Society on the 17th of January, in which they advised the problems we see in the complaint system today are not because of who regulates, but stem from complex, cumbersome and confusing processes required by the statute. I have lodged a significant number of amendments that have been developed following engagement with those bodies involved in a complaint system, and which will streamline and deliver a more proportionate, flexible system to better serve legal practitioners and consumers. And I will, of course, speak to these when these are debated further on in subsequent groups. If I could just address one of the concerns I have with Tess White's amendments is, at the moment, the regulation of the advocates is a responsibility of the Court of Session. So that would be undermining the Court of Session if we move forward with your amendment. That's just one of the concerns I do have. But also, I'm very happy moving forward to Stage 3 to discuss with Tess White how we can strengthen the consumer's voice, which I am trying to do with Stage 2 amendments further down the track.
Thank you. I call Tess White to wind up and to press or withdraw Amendment 541.
Thank you, Convener, and thank you, Minister, for your remarks. I'm not going to push these amendments at stage 2, but I do welcome the opportunity to get on record that I will engage with the Minister and with the stakeholders ahead of stage 3, and thank you also for suggesting and agreeing to meet with me. It's very important that we work together to see how we can further improve the complaints processes, as you say, Minister, for the consumer. My concern is that we've waited for so long for regulatory reform of the legal profession, and that this bill will be a missed opportunity to not only strengthen the complaints process for consumers, but to give them greater protections. The committee took this view at stage 1, and it's important not to be lost in such a huge behemoth of a bill. Consumers, as we've all agreed, and my colleagues have said today, stressed that it's very important that all consumers have a voice in the legislative process too. However, I'll withdraw my objections at this stage. Convener, thank you.
Thank you. Tess White seeks to withdraw Amendment 541. Does any member object to Amendment 541 being withdrawn? No member objects. I call Amendment 67 in the name of the Minister, already debated with Amendment 51. Minister to move formally.
Moved, Convener, sorry.
Thank you. The question is that Amendment 67 be agreed to. Are we all agreed? Yes. We are all agreed. I call Amendment 68 in the name of the Minister, grouped with amendments as shown in the groupings. Minister to move Amendment 68 and to speak to all amendments in the group.
Thank you, Convener. Section 20 of the bill currently allows Scottish ministers to intervene in the event of concerns being raised by the regulator is failing to exercise their regulatory functions in a way that is compatible with the regulatory objectives and takes certain specified measures. Amendments 112 to 116 and 118 to 120 have the effect of transferring the power from the Scottish ministers to the Lord President. Although the regulation-making power, allowing the Scottish ministers to specify intervention measures other than those already provided for that may be taken, is retained in Section 26, Amendment 122 ensures both the Lord President and other stakeholders have a greater role in the process. The amendment provides that the Scottish ministers can only exercise the regulation-making power at the request of the Lord President, who must, before such a request, consult regulators, the consumer panel, and other persons considered appropriate, as well as adhering to certain publication requirements. These provisions will ensure an appropriate level of stakeholder involvement in the exercise of the delegated power. The amendments to Section 20 have been welcomed by both the Law Society and the Senior Judiciary in their recent correspondence to the committee. The amendments also alter the sanctions available, with Amendment 117 removing the ability to impose a financial penalty from the measures available to the Lord President. Amendments 68, 121, 146, 310 and 311 make a consequential change to provisions in the bill, and Amendment 123 makes a small technical change. Convener, Section 19, together with Section 20, provides an important mechanism so that there is a process for review of regulatory performance if concerns are raised about a regulator not upholding the regulatory objectives, and a process allowing specified intervention measures to be taken following such a review. Amendments 93 and 94 reflect the changes of power to the Lord President already discussed. Amendments 95 to 99, 101 and 101 to 111 make further changes to alter the bodies who may seek a review of the performance of the legal services regulator, the criteria for a review, the process for conducting a review, and the types of things a performance review can include. Amendment 99 makes a technical change to clarify that a regulator must provide information about performance when requested by the Lord President, both in connection with a performance review or a decision as to whether to conduct such a review. And Amendment 100 requires the information to be provided within 28 days rather than 21 days. Amendments 102 and 104 insert new provisions into the bill to impose duties on persons other than the relevant regulator in relation to information it holds relating to the performance of that regulator. This will ensure that the Lord President has all the necessary information available when conducting a review. Amendment 105 allows the Lord President, where a regulator has failed to provide the information within 28 days, to add such failure to the existing review, but the regulator must be given an opportunity to respond to the Lord President's proposal. Amendment 103 requires the Lord President to consult such bodies as considered appropriate in conducting a review of performance. Amendment 109 requires the Lord President to also send a copy of the report to the relevant regulator and the requesting body, if any, and 110 requires the Lord President to inform any body who requested a review of any decision not to conduct a review. Amendments 98, 101, 106, 107, 108 and 111 make consequential changes. Amendment 459 inserts new section 86A into the bill. It allows the Lord President to make rules in connection with the exercise of their functions under Part 1 or 2 of the bill. Before making rules, the Lord President must consult the Consumer Panel and each Category 1 and Category 2 regulator. The Lord President is required to publish the rules once finalised, and the transparency provides a check on the exercise of the Lord President's power. Convener, I will move to discuss amendments which are technical and which reflect the substantive changes that have been made to sections 1920 of the bill in relation to powers being with the Lord President. Amendment 147 enables the Lord President to direct a new regulator or a regulator that acquired rights for its members to provide legal services other than rights to conduct litigation and rights of audience under the 1990 Act, to change its regulatory scheme in the manner directed by the Lord President. In other cases, it provides that the Lord President can ask the Scottish ministers to make regulations to make provision to change the regulatory functions or the way in which they are exercised. Amendments 148 to 152 are consequential and technical amendments, as are amendments 156 to 178, with the exception of 169. Amendment 169 requires the Lord President, when proposing to remove all of the regulatory functions of either an accredited regulator or a body that has acquired rights for its members to conduct litigation and acquired rights for audience, to give notice of the intention to authorise providers and consult them. I move Amendment 68 in my name, and I ask members to support the other members in the group. Thank you, Convener.
Thank you. Do any members wish to come in? Would the Minister like to wind up?
No, thank you, Convener.
Thank you. The question is that Amendment 68 be agreed to. Are we all agreed? We are agreed. I call Amendments 69, 70, 71, 72 and 73, all in the name of the Minister and all previously debated with Amendment 51. I invite the Minister to move Amendments 69 to 73 en bloc.
Moved en bloc, Convener.
Does any member object to a single question being put on Amendments 69 to 73? No? The question is that Amendments 69 to 73 be agreed to. Are we all agreed? We are all agreed. The question is that Section 13 be agreed to. Are we all agreed? We are all agreed. I call Amendment 74 in the name of the Minister, already debated with Amendment 51. Minister to move formally.
Move, Convener.
The question is that Amendment 74 be agreed to. Are we all agreed? We are all agreed. I call Amendment 75 in the name of the Minister, already debated with Amendment 51. Minister to move formally.
Move, Convener.
The question is that Amendment 75 be agreed to. Are we all agreed? We are all agreed. The question is that section 14 be agreed to. Are we all agreed? Yes. We're all agreed. The question is that section 15 be agreed to. Are we all agreed? Yes. We are all agreed. I call Amendment 76 in the name of the Minister, already debated with Amendment 51. Minister to move formally.
Move formally, Convener.
The question is that Amendment 76 be agreed to. Are we all agreed? Yes. We are all agreed. I call Amendment 542 in the name of Tess White, already debated with Amendment 541. I would point out that if Amendment 542 is agreed to, I cannot call Amendment 77, which was debated with Amendment 51 in Group Regulatory Framework, Requirements of Regulators, including Governments, because of a pre-emption. Tess White, to move or not to move?
Not moved, Convener.
Not moved. I call Amendments 77, 78, 79, 80, 81, 82 and 83, all in the name of the Minister and all previously debated with Amendment 51. I invite the Minister to move Amendments 77 to 83 en bloc.
Moved en bloc, Convener.
Thank you. Does any member object to a single question being put on Amendments 77 to 83? The question is that Amendments 77 to 83 be agreed to. Are we all agreed? Yes. We are all agreed. The question is that Section 16 be agreed to. Are we all agreed? Yes. We are all agreed. I call Amendments 84, 85, 86, 87, 88, 89 and 90, all in the name of the Minister and all previously debated with Amendment 51. I invite the Minister to move Amendments 84 to 90 en bloc.
Moved en bloc, Convener.
Does any member object to a single question being put on Amendments 84 to 90? The question is that Amendments 84 to 90 be agreed to. Are we all agreed? Yes. We are all agreed. The question is that Section 17 be agreed to. Are we all agreed? Yes. We are all agreed. I call Amendment 91 in the name of the Minister, already debated with Amendment 51. Minister to move formally.
Move formally, Convener.
The question is that Amendment 91 be agreed to. Are we all agreed? Yes. We are all agreed. I call Amendment 92 in the name of the Minister, already debated with Amendment 51. Minister to move formally.
Move, Convener.
The question is that Amendment 92 be agreed to. Are we all agreed? Yes. We are all agreed. The question is that Section 18 be agreed to. Are we all agreed? Yes. We are all agreed. I call Amendments 93, 94, 95, 96, 97, 98, 99, 100, 101, 105, 104, 102, 103, 106, 107, 108, 109, 110 and 111, all in the name of the Minister and all previously debated with Amendment 68. I invite the Minister to move Amendments 93 to 101, 105, 104, 102, 103 and 106 to 111 en bloc.
Moved en bloc, Convener.
Does any member object to a single question being put on Amendments 93 to 101, 105, 104, 102, 103 and 106 to 111? The question is that Amendments 93 to 101, 105, 104, 102, 103 and 106 to 111 be agreed to. Are we all agreed? We are all agreed. The question is that Section 19 be agreed to. Are we all agreed? We are all agreed. I call Amendments 112, 113, 114, 115, 116, 117, 118, 119, 120, 121, 310, 311, 122 and 123, all in the name of the Minister and all previously debated with Amendment 68. I invite the Minister to move Amendments 112 to 121, 310, 311, 122 and 123 en bloc. Does any member object to a single question being put on amendments 112 to 121, 310, 311, 122 and 123? No. The question is that amendments 112 to 121, 310, 311, 122 and 123 be agreed to. Are we all agreed? Yes. We are all agreed. The question is that section 20 be agreed to. Are we all agreed? Yes. We are all agreed. I call amendments 124, 125, 126, 127, 128, 129, 130, 131, 132, 133, 134, 135, 136, 137, 138, 139, 140, 141, 142, 143, 144, 145, 146, 147, 148, 149, 150, 151, 152, 153, 154, 155, 156, 157, 158, 159, 160, 161, 162, 163, 164, 165, 166, 167, 168, 169, 170, 171, 172, 173, 174, 175, 176, 177 and 178, all in the name of the Minister and all previously debated with Amendment 68. I invite the Minister to move amendments 124 to 178 en bloc.
Moved en bloc, Convener.
Does any member object to a single question being put on amendments 124 to 178? Yeah. The question is that amendments 124 to 178 be agreed to. Are we all agreed? Yes. We are all agreed. The members, it tripped me up now. The question is that Schedule 2 be agreed to. Are we all agreed? Yes. Thank you. I propose at this point that we take 5 minutes to suspend the session and have a comfort break. Thank you. welcome back to the Equalities, Human Rights and Civil Justice Committee and our Stage 2 of the Regulation of Legal Services Bill. I call Amendment 179 in the name of the Minister, grouped with amendments as shown in the groupings. Minister to move Amendment 179 and speak to all amendments in the group.
Thank you. Convener, the special rule changes sections relate to the practice rules and provide regulators with the powers to waive practice rules in defined circumstances for the purpose of promoting innovation or avoiding a regulatory conflict by removing an unnecessary rule or making a rule less onerous where considered necessary or appropriate by the regulator. These waivers are not intended to be permanent, and so the bill incorporates transparency and accountability to the Lord President in the process. The intention of these amendments is to retain the system of special rule changes as set out by the bill as introduced, but to remove some elements, including the requirement to produce a dedicated report every year and introduce more flexibility in other areas in response to concerns by the Law Society. These changes were reached following engagement with the Law Society, who felt that some of the provisions in sections 21, 22, 23 and 24 did not allow for enough flexibility in relation to the granting of waivers. Amendment 179 adds to the conditions already set out in section 21 a condition that a regulator can only give a direction to its member or members if the regulator is satisfied that the direction is compatible with the regulatory objectives. Amendments 180 and 181 add additional circumstances where a direction may be given. This is where the regulator considers the direction is necessary or appropriate in the circumstances. Amendment 182 provides that a direction may not disapply or modify a requirement under the bill or any other enactment. This will ensure that regulators will continue to meet their obligations in respect of the provisions in this bill or any other enactment. Amendments 185 and 186 add to the list of things a direction must specify, including the period of time the direction is to have effect, with Amendment 188 removing the requirement that a direction ceases to have effect after 5 years. Amendment 183 limits the duty of the regulator to consult the Competitions and Markets Authority before giving a direction which could restrict, distort or prevent competition to a significant extent to circumstances only where the direction being given is for the purpose of enabling a new or alternative way of providing or regulating legal services to be piloted. Amendment 184 makes changes to who a copy of the direction is to be given and in what circumstances. Amendment 187 places a new requirement on a legal services provider to whom a direction relates to inform the regulator of any changes in circumstances. Amendment 189 limits the circumstances in which the Lord President may revoke a direction to the directions that have been given by a regulator on the basis that it was desirable for the purpose of enabling new or different ways of providing or regulating legal services to be piloted. Amendment 190 removes the duty to give notice of doing so to the Scottish ministers. Amendment 191 removes section 23 of the bill with the effect of the regulator's duty to prepare a report on each direction is removed. Amendment 194 makes a consequential change to section 24. Section 24 of the bill requires a regulator to establish and maintain a register of directions given under section 21 and sets out what documents the register must contain. Amendments 192 and 193 remove the need to include a copy of the application for or application to amend the direction, and Amendment 196 adds a requirement to specify whether the direction is to have effect for an infinite period. Amendment 195 makes a technical change to denote the placement of the new subparagraphs of section 24 to B. Amendments 197, 198 and 199 are minor technical changes. Convener, Paul O'Kane's amendments 543, 544 and 545 would remove most of the special rule changes provisions and sections 21, 22 and 24 from the bill, and unfortunately I cannot support them. Mr O'Kane's amendment 556 to be debated with Group 12 is not a full replacement for the special measures approach to be taken across sections 21 to 24, as it only applies as it is only to apply only in relation to legal businesses and not all legal services providers. This would leave a gap in terms of the Faculty of Advocates and also in the Association of the Construction Attorneys. So these provisions in the bill do not only apply to the Law Society but to all current and future regulators of legal services in Scotland. The provisions would allow rules to be disregarded where this could bring innovation which can benefit consumers to make a rule less onerous for a legal services provider. The Lord President and the Law Society have been consulted on these Scottish Government amendments. I have listened to the Law Society's comments and I've sought to address their concerns. I also consider it important to retain transparency and oversight by the Lord President following engagement with the senior judiciary. The senior judiciary considered that it was appropriate for the Lord President to have oversight of the special rule changes and have powers to revoke certain types of directions. So I move Amendment 179 in my name, and I ask members to support my other amendments in this group. And I ask Mr O'Kane not to press Amendments 543 to 545, and if he does, I would urge members not to support them in favour of retaining the special rule changes arrangements in this bill. Thank you, Convener.
Thank you. I now call Paul O'Kane to speak to Amendment 543 and other amendments in the group.
Thank you very much, Convener. My amendments 543, 544 and 545 all seek to deal with the issues of waivers by leaving out relevant sections of the bill. The powers contained within Section 21 and Sections 22, 24 seek to provide for powers that already exist and are conferred under the 1980 Act, with the ability to waive most of the existing practice rules that is currently in force and is deemed to work well. I understand, I've listened to what the Minister has said, and I'm looking at the motivation of the Government's desire to bring forward changes to the powers for special rules. But there is, I think, it's unclear perhaps, or there is a lack of clarity, I think, in terms of any concerns or issues that have been raised with waivers and how the system currently works at the moment. Regulators currently going through, the regulators that currently operate a waiver system are going through numerous checks before any waivers granted. Practice is built up over many years of experience and is overseen by dedicated committees conducting due diligence on any applications for waivers. I think in understanding the concerns around the system Government has created in these sections, it's important perhaps to understand that waivers are most often requested and granted in situations where it is of benefit to clients, and there is a need to actually move quickly, which is, I think, the theme that has emerged from our desire within this bill to help speed things up for those who are seeking support and redress. I think the process envisaged in the bill may create a lengthy process which has to run through other bodies, so the Lord President, Scottish Ministers, before any waivers can be granted. And that may add inefficiency and complexity to the system that is actually not there at present. And I actually don't think I've heard compelling arguments to introduce that system. Processes can add time, they can add costs, and they could be to the detriment of the consumer, who will bear the consequences. And I think there are further issues within the system as envisaged by the Government. In most cases, it may not work if waivers were time limited, because the rule must either apply to situation and transaction or not. And I think, in addition, waiver decisions often refer to personal information of the applicant, and that can be commercially confidential, information perhaps about operation or practice and what's going on within the business. So I think it would be, at best, difficult to publish those waiver decisions as the Government envisages, and at worst it might consume more significant time and resource to have to redact those before they're published. So again, I come back to this argument about the length of time it may take when actually what we're trying to do is seek a quicker process. I'm not convinced that there has been large evidence that the current system is broken or is being misused, and perhaps we shouldn't seek to try and fix problems where they don't exist. So I hear what the Minister said, and I hear her challenge to me, but I wonder, in her summing up, if she might say more in terms of her position on special rules and consider what we might do further in this area. Thank you.
Thank you. Does any other member wish to come in? No? Would the Minister like to wind up?
Thank you very much, Convener, and I thank Paul O'Kane for his comments. I think in relation to Amendment 453, under rules under the Solicitors Scotland Act 1980, the waivers apply only to the Law Society of Scotland. So I think one of the things is that, as I mentioned, it will leave a gap in terms of the Faculty of Advocates and the Association of Construction of Attorneys, and as we're moving forward, we want it to also apply to current and future regulators of legal services in Scotland. There has been a lot of engagement regarding waivers with the Lord President on this issue, so it would be something that we'd have to engage further with him if we were going to change anything moving forward. But one of the things that I would suggest to Mr O'Kane is moving forward to stage 3. I'm happy to look at how we can strengthen it to make you feel more comfortable.
Okay, thank you. The question is that Amendment 179 be agreed to. Are we all agreed? We are all agreed. I call Amendments 180, 181, 182, 183, 184, 185, 186, 187 and 188, all in the name of the Minister and all previously debated with Amendment 179. I invite the Minister to move Amendments 180 to 188 en bloc.
Move, Convener.
Does any member object to a single question being put on Amendments 180 to 188? No. The question is that Amendments 180 to 188 be agreed. Are we all agreed? We are all agreed. I call Amendment 543 in the name of Paul O'Kane, already debated with Amendment 179. Paul O'Kane to move or not move?
On the basis of further discussion, not moved.
Thank you. The question is that Section 21 be agreed to. Are we all agreed? Yes. We are all agreed. I call Amendment 189 in the name of the Minister, already debated with 179. Minister to move formally.
Move, Convener.
The question is that Amendment 189 be agreed to. Are we all agreed? We are all agreed. I call Amendment 190 in the name of the Minister, already debated with Amendment 179. Minister to move formally.
Move formally, Convener.
The question is that Amendment 190 be agreed to. Are we all agreed? Yes. We are all agreed. I call Amendment 544 in the name of Paul O'Kane, already debated with Amendment 179. Paul O'Kane to move or not move?
Not moved.
The question is that Section 22 be agreed to. Are we all agreed? Yes. We are all agreed. I call Amendment 191 in the name of the Minister, already debated with Amendment 179. Minister to move formally.
Moved formally, Convener.
The question is that Amendment 191 be agreed to. Are we all agreed? Yes. We are all agreed. I call Amendments 192, 193, 194, 195, 196, 197, 198 and 199, all in the name of the Minister and all previously debated with Amendment 179. I invite the Minister to move Amendments 192 to 199 en bloc.
Moved en bloc.
Does any member object to a single question being put on Amendments 192 to 199? The question is that Amendments 192 to 199 be agreed to. Are we all agreed? Yes. We are all agreed. I call Amendment 545 in the name of Paul O'Kane, already debated with 179. Paul O'Kane to move or not move?
Not moved.
The question is that Section 24 be agreed to. Are we all agreed? Yes. We are all agreed. I now call Amendment 200 in the name of the Minister, grouped with amendments as shown in the groupings. I point out that Amendments 206, 207 and 208 are preempted by Amendment 548, previously debated in the Group Complaints Commission to investigate and determine all complaints, service conduct and regulatory. Minister to move Amendment 200 and speak to all amendments in the group.
Thank you, Convener. Sections 25 to 27 of the bill allow a body to apply to the Lord President and the Scottish Ministers together to become a new regulator of legal services, accredited to authorised persons to acquire rights to conduct litigation, rights of audience in courts, and the right to provide other types of legal services. The provisions replace and modernise similar provisions contained in the Law Reform Miscellaneous Provisions Scotland Act 1990. Following engagement with the Lord President about the concerns raised by the senior judiciary at stage 1 over the role of Scottish ministers in the regulation of legal services, I gave the undertaking to the committee that I would lodge an amendment to the effect that it would be the responsibility of the Lord President acting alone to consider any application by a body wishing to enter the legal services sector as a new regulator. Amendment 200 does just that, whilst Amendments 211, 212 and 213 make consequential amendments. Amendment 209 inserts a new section 26A into the bill to give Scottish ministers a power to specify in regulations what additional regulatory matters must be dealt with in a draft regulatory scheme. But Scottish ministers can only exercise this power if they have received a request to do so from the Lord President, an accredited regulator, or the Consumer Panel following a period of consultation with the specified bodies. Except where the Lord President is the requester, the Lord President's agreement must be obtained to the request. To address concerns raised by the senior judiciary, Amendments 201, 203, 206, 207 and 210 make changes to the application requirements, including in respect of the draft regulatory scheme that must accompany an application for accreditation, with Amendments 202, 204, 205 and 208 being consequential amendments. The purpose of Amendments 214 to 224 and 227 is to remove the involvement of Scottish ministers in any consideration of the application and the accompanying draft regulatory scheme, leaving it to the Lord President alone. The amendments also introduce additional requirements for consultation and for transparency. Amendments 225 and 226 place an additional duty on the Lord President to consult the Scottish ministers, as well as the Competitions and Markets Authority, the Consumer Panel and other persons considered appropriate where the Lord President is considering a draft regulatory scheme. Amendments 228 to 231 are consequential. Amendments 232 imposes a new requirement in new sections 29(2)A and 2B on the Lord President to publish the decision on an application under section 25 by a prospective regulator seeking accreditation. Amendment 233 removes the requirement for the Scottish ministers to make regulation to give effect to the draft regulatory scheme, and Amendment 234 requires an applicant to give effect to and publish an approved regulatory scheme. Amendment 235 makes a consequential amendment. The committee will be aware from correspondence from the Lord President and the Law Society that these amendments are welcomed by the senior judiciary and from the legal profession. And I move Amendment 200 in my name, and I ask that members to support the other amendments in this group. Thank you, Convener.
Thank you. Do any members wish to come in? Does the Minister wish to wind up?
No, thank you, Convener.
Thank you. The question is that Amendment 200 be agreed to. Are we all agreed? Yes. We're all agreed. I call Amendment 201 in the name of the Minister, already debated, with Amendment 200. Minister to move formally.
Move formally, Convener.
The question is that Amendment 201 be agreed to. Are we all agreed?
Yes.
We're all agreed. The question is that Section 25 be agreed to. Are we all agreed? Yes. We're all agreed. I call Amendments 202, 203, 204 and 205, all in the name of the Minister and all previously debated with Amendment 200. I invite the Minister to move Amendments 202 to 205 en bloc.
Moved en bloc, Convener.
Does any member object to a single question being put on Amendments 205 to 202 to 205? The question is that Amendments 202 to 205 be agreed to. Are we all agreed? Yes. We are all agreed. I call Amendment 546 in the name of Tess White, already debated with Amendment 541. Tess White to move or not move?
Not moved, Convener.
Okay. I call Amendment 547 in the name of Tess White, already debated with Amendment 541. Tess White to move or not move?
Not moved, Convener.
I call Amendment 548 in the name of Tess White, already debated with Amendment 541. I would point out that if Amendment 548 is agreed to, I cannot call Amendments 206, 207 and 208 because of a preemption. Tess White to move or not move?
Not moved, Convener.
I call Amendment 206 in the name of the Minister, already debated with Amendment 200. Minister to move formally.
Move formally, Convener.
The question is that Amendment 206 be agreed to. Are we all agreed? Yes. We are all agreed. I call Amendment 207 in the name of the Minister, already debated with Amendment 200. Minister to move formally.
Move formally, Convener.
The question is that Amendment 207 be agreed to. Are we all agreed? Yes. We are all agreed. I call Amendment 208 in the name of the Minister, already debated with Amendment 200. Minister to move formally.
Move formally, Convener.
The question is that Amendment 208 be agreed to. Are we all agreed? Yes. We are all agreed. The question is that Section 26 be agreed to. Are we all agreed? Yes. We are all agreed. I call Amendment 209 in the name of the Minister, already debated with Amendment 200. Minister to move formally.
Move, Convener.
The question is that Amendment 209 be agreed to. Are we all agreed? Yes. We are all agreed. I call Amendments 210, 211, 212 and 213, all in the name of the Minister and all previously debated with Amendment 200. I invite the Minister to move Amendments 210 to 213 en bloc.
Moved en bloc, Convener.
Does any member object to a single question being put on Amendments 210 to 213? The question is that Amendments 210 to 213 be agreed to. Are we all agreed? We are all agreed. The question is that Section 27 be agreed to. Are we all agreed? We are all agreed. I call Amendments 214, 215, 216, 218, 217, 219, 220, 221, 222, 223, 224, 225, 226 and 227, all in the name of the Minister and all previously debated with Amendment 200. I invite the Minister to move Amendments 214 to 216, 218, 217 and 219 to 227 en bloc.
Moved en bloc, Convener.
Does any member object to a single question being put on Amendments 214 to 216, 218, 217 and 219 to 227? The question is that Amendments 214 to 216, 218, 217 and 219 to 227 be agreed to. Are we all agreed? Yes. We are all agreed. The question is that Section 28 be agreed to. Are we all agreed? Yes. We are all agreed. I call Amendments 228, 229, 230, 231, 232, 233 and 234, all in the name of the Minister and all previously debated with Amendment 200. I invite the Minister to move Amendments 228 to 234 en bloc.
Moved en bloc, Convener.
Does any member object to a single question being put on Amendments 228 to 234? The question is that Amendments 228 to 234 be agreed to. Are we all agreed? We are all agreed. The question is that Section 29 be agreed to. Are we all agreed? We are all agreed. I call Amendment 235 in the name of the Minister, already debated with Amendment 200. Minister to move formally.
Moved, Convener.
The question is that Amendment 235 be agreed to. Are we all agreed? We're all agreed. The question is that Section 30 be agreed to. Are we all agreed?
Yes.
We're all agreed. I call Amendment 236 in the name of the Minister, grouped with amendments as shown in the groupings. Minister to move Amendment 236 and to speak to all amendments in the group.
Thank you, Convener. Linked to the previous amendments in Group 8, removing the role of the Scottish Ministers from the process of acquiring and exercising the right to provide legal services, Amendment 236 removes the involvement of the Scottish Ministers in respect of an application enabled under Section 31 of the Bill by an accredited regulator to surrender its acquired rights, and Amendments 238, 239, 242, 243 and 244 are consequential. Applications are to be made to the Lord President alone. Amendment 240 inserts a new subsection 2A into Section 30, making particular provision where an application is to surrender all of the regulator's acquired rights. The consultation undertaken by the regulatory body under subsection 1A must seek the views of the body's authorised providers about whether a majority of the providers would like another regulator to authorise them to exercise and regulate their rights, or to form a body and submit an application under section 25 to seek accreditation to authorise them to exercise and regulate their acquired rights. Amendment 245 provides that the direction-making power under Section 30 is exercisable by the Lord President acting alone rather than together with Scottish ministers. Amendments 246 and 247 provide that these directions can be varied or revoked by the Lord President. Amendment 248 makes changes to the conditions and process of granting an application to surrender some of or all of the acquired rights, placing publication and notification requirements on the Lord President. Amendment 249 provides that where all of the regulator's rights are to be surrendered, the Lord President's notice may provide that the notice takes effect when either the regulator's legal services providers are authorised by a new regulator, or when the providers form a new body and that body becomes an authorised regulator. Section 34 of the Bill on Revocation of Acquired Rights allows the Scottish ministers to revoke the approval of an application under Section 29 where it appeared to them that the body that made the application had failed to comply with the direction under Section 33. Amendments 264, 265, 266 and 269 reflect the shifting of the role to the Lord President alone. Amendments 267 and 268 set out the notification, publication and consultation steps the Lord President must take where the Lord President wishes to revoke the approval. The Bill granted ministers the power to intervene by establishing a new regulator, transferring rights to another regulator, or, if necessary, assuming direct regulatory responsibilities themselves. Amendment 270 transfers the responsibility and authority to the Lord President. Amendment 270 introduces a new section which instead gives the powers to the Lord President to seek appropriate arrangements where an accredited regulator is a discontinuing regulator. This involves consulting each authorised provider to determine in particular whether a majority of the authorised providers would like another regulator to authorise and regulate them. If the majority is in favour of another regulator authorising and regulating the providers, the Lord President, where the new receiving regulator is an accredited regulator or a body which has had an application under Section 25 of the Law Reform Miscellaneous Provisions Scotland Act 1990 granted, can amend the regulatory functions of the receiving regulator to enable it to regulate the authorised providers of the discontinuing regulator. In any other case, the Lord President can ask the Scottish ministers to make regulations subject to the affirmative procedure to amend the functions of the receiving regulator. As noted with the previous group, the Lord President and the Law Society have welcomed these amendments, and I move Amendment 236 in my name, and I ask that members support each of the amendments in the group. Thank you, Convener.
Thank you. Do any members wish to come in? Does the Minister wish to wind up?
No, thank you, Convener.
Thank you. The question is that Amendment 236 be agreed to. Are we all agreed? Yes. We are all agreed. I call Amendments 237, 238, 239, 240, 241, 242, 243, 244, 245, 246, 247, 248 and 249, all in the name of the Minister and all previously debated with Amendment 236. I invite the Minister to move Amendments 237 to 249 en bloc.
Moved on block, Convener.
Okay. Does any member object to a single question being put on Amendments 237 to 249? The question is that Amendments 237 to 249 be agreed to. Are we all agreed? We are all agreed. The question is that Section 31 be agreed to. Are we all agreed? We are all agreed. I call Amendment 250 in the name of the Minister, grouped with Amendments 455, 456, 457 and 458. Minister to move Amendment 250 and speak to all amendments in the group.
Thank you, Convener. Amendments 455 and Amendment 456 respectively amend the new offences of taking or using the title of lawyer or of pretending to be a regulated legal services provider. These amendments will increase public protection regarding the term lawyer, as false use of the term lawyer will now be an offence without having to also commit intent to deceive. Likewise, a person can no longer falsely advertise that they are regulated. Public polling by the government and the Law Society has shown support for the title lawyer being given the same protection as solicitor. This was considered important to protect the consumer, who may not understand the distinction between the two when seeking legal services from a regulated professional. The committee has also heard anecdotal evidence of solicitors being struck off and subsequently providing unregulated legal services to the public using the title of lawyer. We view that there is a public protection concern in such cases. Amendment 457 makes changes to Section 84 of the bill to make it an offence for a person who is not a member of the Faculty of Advocates to, without reasonable excuse, take or use a name, title, addition or description implying that the person is a member of the faculty. Currently, a person only commits an offence if the person pretending to be an advocate does so with intent to deceive. This amendment would mean that there is no longer any need to prove intent to deceive for the offence to be committed. Amendment 250 widens the offence of pretending to be authorised to exercise acquired rights to include any false claim of authorisation without a reasonable excuse, not just those made with the intent to deceive. Amendment 458 alters the power for Scottish ministers to make regulations to amend Section 32 of the 1980 Act to make provision for, or in connection with it being an offence for an unqualified person to draw or prepare certain documents or provide certain other legal services. Instead of being able to themselves initiate the regulation-making power, Scottish ministers will only be able to exercise a power following a request to do so from the Lord President, a regulator or the Consumer Panel. Prior to making a request, the requesting body must consult the bodies, other than themselves, in the list and secure agreement with the Lord President. This amendment seeks to add an approval mechanism for the Lord President before Scottish ministers can seek to make regulations in this area. I move, Convener, Amendment 250 in my name, and I ask that members to support each of the amendments in our group. In this group.
Thank you. I call Paul O'Kane, please.
Thank you, Convener. Just a brief comment to thank the Minister for the amendments that she has brought in this group. She will be aware that it's one area which I think exercised many witnesses at stage 1, and I had raised concerns about the need to strengthen and alter provisions contained in these sections back throughout, I think, the stage 1 process, as other colleagues did in terms of my meeting with the Minister. I think it's important that consumer protection is forefront in our mind in ensuring that unscrupulous individuals who would seek to misrepresent themselves as lawyers or solicitors are holding the public office of advocate are held to account, and we ensure there is a safeguard against that. So I do believe that the government's amendments in the group will provide a solution to that, and indeed to those original concerns that we heard in evidence, and I will support the amendments in the group. Thank you.
Thank you. Does any other member? Margie Chapman, please.
Thanks very much, Convener. Just to echo the comments that Paul O'Kane has made, I think we heard in the evidence that we gathered for stage 1 that the very real concerns that people have about the intention or otherwise to mislead people by using certain titles, and like Paul O'Kane has indicated, I think these amendments satisfy those concerns and give the protections to the consumers that we were wanting to see. So thank the Minister for bringing them forward, and we'll also be supporting them.
Thank you. Would the Minister like to wind up?
No, thank you, Convener.
Thank you. The question is that Amendment 250 be agreed to. Are we all agreed? We are all agreed. The question is that Section 32 be agreed to. Are we all agreed? We are all agreed. I call Amendment 251 in the name of the Minister, grouped with amendments as shown in the groupings. Minister to move Amendment 251 and to speak to all amendments in the group.
Thank you, Convener. The effect of Amendment 252 is to require an accredited regulator to review its regulatory scheme if directed to do so by the Lord President. It removes the ministerial involvement in triggering the review process as provided for under the bill. A regulator also has the power to initiate such a review itself, and where it does so and proposes a revision, Amendment 251 requires it to provide a report of the revision to the Lord President, who can either approve the revision or not, or direct such other revision is made. Amendments 253 to 259 and 261 are consequential on the removal of the role of the Scottish ministers from the process. Amendment 260 gives a new power, allowing the Lord President to comment on an accredited regulator's proposed revisions to its regulatory scheme and direct the regulator to take account of such comments before giving the Lord President a revised report containing any revision to the scheme. Amendment 262 places a requirement on the regulator to publish its revised scheme. Amendment 263 gives the Lord President the power to revoke or vary any direction they have given. And I move, Convener, Amendment 251 in my name, and I ask that members to support my other amendments in this group.
Thank you. Do any members wish to come in? No. Does the Minister want to wind up?
No, thank you, Convener.
Thank you. The question is that Amendment 251 be agreed to. Are we all agreed? We are all agreed. I call amendments 252, 253, 254, 255, 256, 257, 258, 259, 260, 261, 262 and 263, all in the name of the Minister and all previously debated with Amendment 251. I invite the Minister to move amendments 252 to 263 en bloc.
Moved en bloc, Convener.
Thank you. Does any member object to a single question being put on amendments 252 to 263? The question is that amendments 252 to 263 be agreed to. Are we all agreed? We are all agreed. The question is that section 33 be agreed to. Are we all agreed? We are all agreed. I call amendments 264, 266, 265, 267, 268 and 269, all in the name of the Minister and all previously debated with Amendment 236. I invite the Minister to move amendments 264, 266, 265 and 267 to 269 en bloc.
Moved en bloc, Convener.
Does any member object to a single question being put on amendments 264, 266, 265 and 267 to 269? Yep. The question is that amendments 264, 266, 265 and 267 to 269 be agreed to. Are we all agreed? Yes. We are all agreed. The question is that section 34 be agreed to. Are we all agreed? I call Amendment 270 in the name of the Minister, already debated, with Amendment 236, Minister to move formally. The question is that Amendment 270 be agreed to. Are we all agreed? We are all agreed. The question is that sections 36 and 37 be agreed to. Are we all agreed? Yes. We are all agreed. I call Amendment 271 in the name of the Minister, grouped with amendments as shown in the groupings. Minister to move Amendment 271 and speak to all amendments in the group.
Thank you, Convener. These amendments relate to Part 2 of the Bill, which makes provision for Category 1 regulators to authorise legal businesses to provide legal services. Amendment 273 and 642 extend the definition of authorised legal businesses to include business entities owned by a solicitor or solicitors jointly with a person or person regulated by a Category 1 regulator, and clarifies that a business may be wholly owned either directly or through one or more other bodies, or partly directly and partly through one or more other bodies. These amendments address a concern that was raised by the Law Society that various types of business entities are not covered by the provisions. It is an offence under Section 39 liable to a £20,000 fine for a person to own or operate a legal business which provides legal services to the public for a fee, gain or reward without that business being authorised under Part 2 of the Bill. The Scottish Ministers have the power to change the amount of that fine by regulations, and Amendment 274 requires them to consult each Category 1 regulator and other persons considered appropriate before making such regulations and publish any responses to the consultation. Amendment 275 has the effect of treating a sole solicitor, a firm of solicitors, an incorporated practice and a multinational practice, all as defined in the Solicitors Scotland Act 1980, as authorised by the Law Society of Scotland to provide legal services to the public for a fee, gain or reward on the coming into force of the section. This amendment meets a request by the Law Society of Scotland that existing authorised legal businesses can be passported into authorisation when the relevant provisions of the Bill commence, so that existing legal businesses are deemed to be authorised rather than all having to go through the authorisation process at the same time. The Bill's Section 40 introduced the offence of, with the intent to deceive, taking or using any name, title, addition or description implying that the person is an authorised legal business or otherwise pretending to be an authorised legal business. Amendment 276 removes the intent to deceive ground with the offence, replacing it with without reasonable excuse. And this aligns with our discussions with the Law Society in respect of the offences of pretending to be regulated. Responding to the views from the Law Society, Amendment 277 imposes a new requirement on Scottish ministers to consult each Category 1 regulator and other persons considered appropriate before making regulations to increase the maximum penalty for an offence of pretending to be an authorised legal business and publish responses. Section 41 requires a Category 1 regulator to prepare and operate a set of rules to authorise and regulate legal businesses referred to in the Bill as ALB rules. Amendment 279 expands what legal businesses and legal services ALB rules may relate to by including services other than legal services that form part of the professional practice of solicitors or individuals regulated by the Category 1 regulator within the legal business, within our legal business. Amendment 280 transfers the power to approve an amendment to ALB rules to the Lord President rather than the Scottish ministers. Amendment 281 is to restrict the requirement to consult about changes to ALB rules to apply only in cases where the change is material. Amendment 283 requires a consultation response to be submitted with the amendment of the rules sought by the regulator, and Amendment 282 makes a consequential change to that. Section 412C confers power on the Scottish ministers to specify in regulations such other regulatory matters that ALB rules are to deal with. Amendment 284 and 285 provide that the Scottish ministers may only exercise this power when requested to do so by either the Lord President, the Consumer Panel, or a Category 1 regulator. The provisions also specify the process in respect of consultation and for obtaining the Lord President's approval. Amendment 288 provides the regulator's rules for authorising legal businesses may make provision about imposing or varying the conditions or restrictions applying to existing authorisations. Amendment 291 adds to the list of things authorisation rules can be about to include circumstances in which an authorised legal business may surrender its authorisation. Amendment 289 means the renewal of a legal business's authorisation is no longer one of the particular matters that the authorisation rules must include, and Amendments 293 and 298 are consequential to that. Amendment 292 removes examples of particular fees that may be covered by authorisation rules, such as a fee for renewal, leaving a general provision stating that authorisation rules can be about chargeable fees. Amendment 295 provides that authorisation rules can include rules or arrangements relating to the continued authorisation of a legal business that is a partnership other than a limited liability partnership if a person ceases to be a partner or a person is admitted as a partner. The purpose of this amendment is to provide clarity regarding such arrangements following a request by the Law Society. Both Amendments 296 and 297 amend Section 43 to recognise a right of appeal to the Sheriff by an authorised legal business against a regulator's decision after an internal review. Amendment 299 provides that the Sheriff may impose, vary or revoke conditions or restrictions in relation to that appeal. Section 45 allows practice rules under Section 44 to provide for the imposition of a financial penalty. Amendments 301 and 302 provide for the withdrawal of the imposition of a financial penalty where the regulator considers that it is not reasonable to seek payment of it. Amendment 303 provides that the regulator can recover from the authorised legal business the reasonable cost of collecting any financial penalty imposed on the business. The purpose of this amendment is to allow the regulator to recover costs that they will incur when collecting any financial penalty from the authorised legal business. Section 45(2) of the Bill allows the Scottish ministers by regulations to specify the maximum amount that the financial penalty can be, and Amendment 304 requires the Scottish ministers to consult the Category 1 regulator and other person or bodies considered appropriate before making such regulations and to publish responses. Amendment 305 provides that Scottish ministers can only make regulations in respect of reconciling different sets of regulatory rules if they have received a request from the Lord President, a Category 1 regulator or the Consumer Panel, who have undertaken a period of consultation and have included with the request information about the consultation responses received. Following the requester must publish documents included in the request. Amendment 308 requires the Law Society to seek the approval of its first ALB rules under the Bill. Amendment 309 removes the Section 49, which would have allowed Scottish ministers to intervene to establish a body with a view to it becoming a Category 1 regulator or allow for direct authorisation by ministers. I wrote to the committee in January and April of last year accepting that the risk of the Law Society of Scotland being unable to operate its regulatory functions as a Category 1 regulator is low and undertook to lodge at stage 2 to remove Section 49. Amendments 271, 272, 278, 286, 287, 290, 294, 300, 306 and 307 are minor, technical and consequential points. As I mentioned in Group 7 on special rule changes, Paul O'Kane's Amendment 556 in the current group is not a full replacement for the special measures approach to be taken, as it would only apply in relation to legal businesses and not all legal services providers. This would leave, as I said previously, this would leave a gap in terms of the Faculty of Advocates and the Association of Construction Attorneys. So unfortunately, I can't support it. In terms of Pam Gossel and Paul O'Kane's amendments 549 to 556 and 641, amendments 273 and 642 in my name would cover a mixture of the legal business as wholly owned by either solicitors or qualifying individuals, and will cover registered foreign lawyers where appropriate. Amendment 275 will also address the concerns by confirming the approach in respect of any such multinational practice. And this is subject to alternative provision made by the rules approved under Section 41. This means that the Law Society of Scotland will be able to make rules, but the starting position is that multinational practices that are wholly owned by solicitors enrolled in Scotland or qualifying individuals, or a mixture of both, will be treated as authorised businesses under the controls in Part 2 of the Bill, unless or until the Law Society makes alternative provisions in the rules. Therefore, the amendments in my name do achieve the stated aim while providing a proportionate level of flexibility. And I believe that we all do share the same intention here. And I am happy to consider moving into stage 3 to work up with Pam Gossel and Paul again to see how we can adjust the explanatory notes to the Act to ensure that the position is clear there. I therefore move Amendment 271 in my name, and I ask members to support each of my other amendments in this group. In particular, I would ask members to support my amendments 273 and 642, and not those of Pam Gossel and Paul O'Kane's amendments 549 to 555 and 641. And I would also ask Paul O'Kane not to move his amendment 556 on special rules for legal businesses in favour of the approach taken in the bill to special rule changes for all legal services providers. And if he does move the amendment, I would ask members not to support it. Thank you, Convener.
Thank you. Pam Gossel to speak to Amendment 549 and other amendments in the group.
Thank you, Convener. My Stage 2 amendments to the Regulation of Legal Services Scotland Bill are centred around the definition of legal businesses and how this definition is affected by this bill. Having spoken to representatives from the Law Society, they expressed concerns that the bill makes it difficult for certain businesses to operate in Scotland. The bill defines a legal business as being wholly owned by either solicitors or qualifying individuals, but not a mixture. The language in the bill makes no provision for any share of ownership being held by any registered foreign lawyer, meaning a lawyer that can practice law elsewhere in the United Kingdom. That is why my amendments 549, 551, 552 and 554 clarify that registered foreign lawyers can participate in and own a legal business in combination with solicitors. With regards to other amendments in this group, they also seek to better the definition of legal businesses, which, as drafted, is not wide enough to cover ownership and employment out of Scotland. Amendments 553, 555 and 641 in the name of Paul O'Kane build on my amendments by adding a combination of persons by which a law firm can be owned. These are amendments I am happy to support. I'm also happy to support Amendment 556, which adds to the list of what authorised legal business rules should contain. Scottish Government's Amendments 271, 272 and 274 to 309 significantly remove powers of Scottish Government ministers to regulate the legal sector and offer clarity where needed. That is why I am happy to support these amendments as well.
Thank you. I ask Paul O'Kane to speak to Amendment 554 and other amendments in the group.
Thank you very much, Convener. And the principal amendments which I have lodged in this space deal with the issue of registered foreign lawyers and the regulation of legal businesses therein. Much of the content and purpose, I think, of my amendments is similar to what Pam Gossel has outlined in terms of how we ensure that there is no detriment to businesses that are trying to operate within Scotland. So I don't intend to repeat too much of that for the benefit of committee and for the Minister. But I think what has been raised throughout the process with me is the issue of registered foreign lawyers more generally. Whilst many come from qualifying jurisdictions within and beyond Europe, I do think we have to reflect jurisdictions in which relevant law firms who provide legal services internationally, that many of their solicitors are actually within the United Kingdom, so either England, Wales or Northern Ireland. And evidently there would be much cross-border work with Scotland. We want to avoid a situation where that would not be possible because of the definition of a registered foreign lawyer, because I think it's important that we recognise both that, but also that there are safeguards in place in terms of some of the issues that have been raised already in debate. A foreign lawyer can only be registered if they are to be an owner of a practice, where at least one other qualified lawyer is able to practice in Scotland. They can't just practice as sole practitioners or provide legal services which are reserved to those who are qualified in Scotland. My worry, and I've heard what the Minister said in terms of guidance, I do think it would be useful to have it in statute in terms of just those definitions being quite clear in terms of what it is we are trying to achieve. And as I say, I note that Pam Gossel's amendments are similar to mine, but I do think on the basis of the advice I've taken that mine actually will move forward what it is we're trying to advance. So I appreciate there is something of a duplication there. I'll just briefly, if I can, convener on the other amendments. I would recognise what the Minister has said in her previous offer in terms of trying to work together to look at how we might broaden the scope of regulation. So I'm happy to meet with her on those issues ahead of stage 3 and see how we might further develop those in terms of, as I say, the previous discussion we had this morning. So I think more broadly on this group, the Minister has done important work in terms of amendments, and I believe the majority of the amendments in the group make good improvements to other parts, other sections within the parts of the bill, and so I will support those amendments. But I do think we need to be quite clear on this issue about registered foreign lawyers to ensure that there is no detriment in terms of particularly those cross-border issues.
Thank you. Does any other member wish to come in? No. Does the Minister wish to wind up?
Thank you, Convener. I do believe that the Scottish Government Amendments 273 and 642 in my name, that these amendments do achieve the intention behind Pam Gossel's and Paul O'Kane's Amendment 549, 555 and 641. Considering that they are qualifying individuals and they are covered, foreign also will cover registered foreign lawyers where appropriate. I know this is very technical, so I am very happy to have further discussions moving into stage 3 and how we improve things.
Thank you. The question is that Amendment 271 be agreed to. Are we all agreed? Yes. Yes, we are agreed. I call Amendment 272 in the name of the Minister, already debated with Amendment 271. Minister to move formally.
Moved, Convener. Thank you.
The question is that 272 be agreed to. Are we all agreed? Yes, we are all agreed. The question is that Section 38 be agreed to. Are we all agreed? We're all agreed. I call Amendment 549 in the name of Pam Gossel, already debated with Amendment 271. Pam Gossel to move or not move.
Thank you, Convener. I'd like to thank the Minister for her engagement on this bill from the meeting last week. I would also like to acknowledge the amendments she has brought forward. However, after speaking with the Law Society, I believe that my amendments sufficiently clarify nuances when it comes to the ownership of legal businesses. For example, Amendment 549 clarifies that a solicitor can constitute a foreign solicitor, which the section does not make clear, nor do any of the other amendments. Sorry.
At this point, it's to move the amendment or to not move,
Okay, right,
not
okay.
to respond.
Well, I'm happy to basically, in light with what the Minister has said, if she's going to obviously discuss with us on stage 3, to not to move the amendment, but I also want to put these points on record, that how important these points are, and at this moment they're not being clarified. Sorry, amended. Thanks.
Thank you. I call Amendment 550 in the name of Paul O'Kane, already debated, with Amendment 271. Paul O'Kane to move or not move.
Not moved.
I call Amendment 551 in the name of Pam Gossel, already debated, with Amendment 271. Pam Gossel to move or not move.
Not moved.
I call Amendment 552 in the name of Pam Gossel, already debated, with Amendment 271. Pam Gossel to move or not move.
Not moved.
I call Amendment 273 in the name of the Minister, already debated, with Amendment 271. Minister to move formally.
Move, Convener.
The question is that Amendment 273 be agreed to. Are we all agreed?
Yes.
We're all agreed. I call Amendment 553 in the name of Paul O'Kane, already debated, with Amendment 271. Paul O'Kane to move or not move.
Not moved.
I call Amendment 554 in the name of Pam Gossel, already debated, with Amendment 271. Pam Gossel to move or not move.
Not moved.
I call Amendment 2642 in the name of the Minister, already debated, with Amendment 271. Minister to move formally.
Moved, Convener.
The question is that Amendment 642 be agreed to. Are we all agreed? We're all agreed. I call Amendment 274 in the name of the Minister, already debated, with Amendment 271. Minister to move formally.
Move, Convener.
The question is that Amendment 274 be agreed to. Are we all agreed? Yes. We're all agreed. I call Amendment 555 in the name of Paul O'Kane, already debated, with Amendment 271. Paul O'Kane to move or not move.
Not moved.
I call Amendment 275 in the name of the Minister, already debated, with Amendment 271. Minister to move formally.
Move, Convener.
The question is that Amendment 275 be agreed to. Are we all agreed? Yes. The question is that Section 39 be agreed to. Are we all agreed? Yes. We're all agreed. I call Amendment 276 in the name of the Minister, already debated, with Amendment 271. Minister to move formally.
Move formally, Convener.
The question is that Amendment 276 be agreed to. Are we all agreed? Yes. We're all agreed. I call Amendment 277 in the name of the Minister, already debated, with Amendment 271. Minister to move formally.
Move formally, Convener.
The question is that Amendment 277 be agreed to. Are we all agreed? We're all agreed. The question is that Section 40 be agreed to. Are we all agreed? We're all agreed. I call Amendment 278 in the name of the Minister, already debated, with Amendment 271. Minister to move formally.
Move, Convener.
The question is that Amendment 278 be agreed to. Are we all agreed? Yes. We're all agreed. I call Amendment 556 in the name of Paul O'Kane, already debated, with Amendment 271. Paul O'Kane to move or not move.
Not moved.
I call Amendments 279, 280, 281, 282, 283, 284, 285, 286 and 287, all in the name of the Minister and all previously debated, with Amendment 271. I invite the Minister to move Amendments 279 to 287 en bloc.
Moved en bloc, Convener.
Does any member object to a single question being put on Amendments 279 to 287? No. The question is that Amendments 279 to 287 be agreed. Are we all agreed? Yes. The question is that Section 41 be agreed to. Are we all agreed? Yes. We're all agreed. I call Amendments 288, 289, 290, 291, 292, 293, 294 and 295, all in the name of the Minister and all previously debated, with Amendment 271. I invite the Minister to move Amendments 288 to 295 en bloc.
Moved en bloc, Convener.
Does any member object to a single question being put on Amendments 288 to 295? The question is that amendments 288 to 295 be agreed to. Are we all agreed? Yes. We're all agreed. The question is that section 42 be agreed to. Are we all agreed? Yes. We're all agreed. I call amendments 296, 297, 298 and 299, all in the name of the Minister and all previously debated with Amendment 271. I invite the Minister to move amendments 296 to 299 en bloc.
Moved en bloc, Convener.
Does any member object to a single question being put on amendments 296 to 299? No. The question is that amendments 296 to 299 be agreed to. Are we all agreed? Yes. We're all agreed. The question is that section 43 be agreed to. Are we all agreed? Yes. We're all agreed. I call amendment 300 in the name of the Minister, already debated with amendment 271. Minister to move formally.
Moved, Convener.
The question is that amendment 300 be agreed to. Are we all agreed? Yes. That is agreed. The question is that section 44 be agreed to. Are we all agreed? Yes. We're all agreed. I call amendments 301, 302, 303 and 304, all in the name of the Minister and all previously debated with amendment 271. I invite the Minister to move amendments 301 to 304 en bloc.
Moved en bloc, Convener.
Does any member object to a single question being put on amendments 301 to 304? The question is that amendments 301 to 304 be agreed to. Are we all agreed? We're all agreed. The question is that section 45 be agreed to. Are we all agreed? We're all agreed. I call amendment 305 in the name of the Minister, already debated with amendment 271. Minister to move formally.
Moved, Convener.
The question is that amendment 305 be agreed to. Are we all agreed? Yes. We're all agreed. The question is that section 46 be agreed to. Are we all agreed? Yes. We're all agreed. I call amendment 306 in the name of the Minister, already debated with amendment 271. Minister to move formally.
Moved, Convener.
The question is that amendment 306 be agreed to. Are we all agreed? Yes. We're all agreed. I call amendment 307 in the name of the Minister, already debated with amendment 271. Minister to move formally.
Moved, Convener.
The question is that amendment 307 be agreed to. Are we all agreed? Yes. We're all agreed. The question is that section 47 be agreed to. Are we all agreed? Yes. We're all agreed. I call amendment 308 in the name of the Minister, already debated with amendment 271. Minister to move formally.
Moved formally, Convener.
The question is that amendment 308 be agreed to. Are we all agreed? Yes. The question is that section 48 be agreed to. Are we all agreed? Yes. We're all agreed. I call amendments 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25 and 26, all in the name of the Minister and all previously debated with Amendment 47. I invite the Minister to move amendments 5 to 26 en bloc.
Moved en bloc, Convener.
Does any member object to a single question being put on amendments 5 to 26? The question is that amendments 5 to 26 be agreed to. Are we all agreed? Yes. We're all agreed. I call amendment 27 in the name of the Minister, grouped with amendments 638, 639 and 508. Minister to move amendment 27 and speak to all amendments in the group.
Thank you, Convener. Following engagement with Tess White on Amendment 638, I am content to support this provision and I will not be moving my corresponding Amendment 508. Similarly, I am content to support Paul O'Kane with regard to the amendment in his name, Amendment 639. We may have to revisit this at stage 3 to ensure the revised provisions work fully with the wider legislation and any adjustment to reflect the intention. However, I require to move Amendment 27, which is consequential to the Government's principal amendment 508, just in order to allow debate on this group if necessary, and then I will seek members' permission to withdraw Amendment 27 at the end of the debate. The Government is willing to support Amendment 638 in favour of our Amendment 508, and I would urge members to support Amendments 638 and 639.
you. Tess White to speak to Amendments 638 and other amendments in the group.
Thank you, Convener. I'll speak briefly on Group 13. So my Amendment 638 from the Law Society, along with those from Siobhan Brown and Paul O'Kane, all seek to safeguard the interests of clients in circumstances where an authorised legal business is unable to continue to operate. Such circumstances could include death, incapacity or suspension, for example. The provisions in Amendment 638 repeal sections 45 and 46 of the 1980 Act and replace them with new provisions, sections 45A and 46A. Consequential amendments are made to paragraph 5 of Schedule 3 to the 1980 Act. Client money would be protected immediately by being placed under the control of the regulator, and the regulator would be able to issue directions setting out how other client assets such as files and documents are to be dealt with. Now, I've engaged with the Law Society on this area, who believes that the Scottish Government's Amendment 508 would leave consumers in a worse position than they are today because of potentially time-consuming applications to the court, and these could lead to delays for clients when time is of the essence. So I've also discussed this amendment with the Minister, and I would like to thank her for her constructive engagement, and I appreciate that the Law Society, having the agility and flexibility to respond in situations like this, must come with checks and balances, but we must find a route through it that satisfactorily protects the client. So the Minister has indicated she would be happy for Amendment 638 to replace Scottish Government Amendment 508, so I will press 638, and I'd be happy to engage further with the Minister and the Law Society on these provisions ahead of Stage 3. Thank you.
Thank you. I call Paul O'Kane to speak to Amendment 639 and other amendments in the group.
Thank you very much, Convener. I'm very grateful for the opportunity to speak on this group, but in particular the amendment in my name at 639, and I thank the Minister for her comments and for her acceptance of the amendment, which essentially, I think, does what everyone's intent is within this grouping and this space, which is to seek to ensure that there is fair recovery of costs and I suppose a polluter pays principle in terms of the approach that's made where regulatory objectives have to be additional costs incurred in terms of the pursuit of those regulatory provisions. Obviously, this is about the behaviour of certain individuals and the way that government can legislate in order to support the reclamation of costs, as I say. I think what's clear here is that Tess White's amendment and a number of amendments in this group will merit further discussion in terms of progress to Stage 3, but at this stage I think passing my amendment would begin that process, and I'm very grateful.
Thank you. Would the Minister like to wind up?
No, just thank you to Paul O'Kane and Tess White for their amendments, and I'm happy to support them. But as I said in my opening speech, we just have to, at Stage 3, ensure that the revised provisions work fully within the wider legislation. And sorry, I'm going to withdraw 27.
Thank you. The Minister seeks to withdraw Amendment 27. Does any member object to the amendment being withdrawn? No, there are no objections, so the amendment is withdrawn. I call amendments 28, 29, 30, 31, 32, 33, 34, 35, 36 and 37, all in the name of the Minister and all previously debated with Amendment 47. I invite the Minister to move amendments 28 to 37 en bloc.
Moved en bloc, Convener.
Does any member object to a single question being put on amendments 28 to 37? The question is that amendments 28 to 37 be agreed to. Are we all agreed? We are all agreed. The question is that Schedule 1 be agreed to. Are we all agreed? We are all agreed. I call Amendment 309 in the name of the Minister, already debated with Amendment 271. Minister to move formally.
Moved, Convener.
The question is that Amendment 309 be agreed to. Are we all agreed? Yes. We're all agreed. The question is that Section 50 be agreed to. Are we all agreed? Yes. We are agreed. Thank you. This concludes today's meeting, and next week we will continue our Stage 2 consideration of the Regulation of Legal Services Scotland Bill. Members are reminded that the deadline for amendments to those parts of the bill that we have not yet reached is 12 noon tomorrow, and we will start next week's meeting at 9:30. I now close this meeting. Thank you.